Justice Alito?
Let me see if I understand the colloquy you just had with Justice Kagan and the degree to which you agree with what she said. Did either Hall or Moore hold anything with respect to how a case must be treated when there are multiple scores? Hall and Moore talk about one score, and they say that dealing with multiple scores is a complicated matter. But do they say anything about how a court is to deal with a situation where there are more than one scores?
No, not expressly.
So if there is a case with one score and the standard error of measurement has a range that is below 70, and that's it. That's all that's in the case. One score, standard error of measurement is below 70. Yes, Hall says that allows the prisoner to proceed with evidence about adaptive functions. But it doesn't say how the court is to deal with a situation where there are multiple scores.
That's correct. And this is what I was trying to get at before, is that I do think in a lot of the solutions that I think might come with concerns that come with looking at injecting adaptive functioning into this space is I do think states have some discretion about when you want to sort of focus on IQ alone as a threshold matter. And I do think to the extent that a defendant or just can't come in and show that your multiple scores have any realistic possibility of dipping below any concerning range, that is a time where a state can say, we don't want to inject any of this other stuff into it, just focus on IQ.
Okay, so what we are looking for here under our precedents is the evolving standard of decency that exists on this issue about how to decide whether someone who's sentenced to death has significantly sub-average intellectual functioning. In prior cases where we have tried to determine what the national consensus is, we have looked at state laws, things that are enacted by the state legislature, on the theory that they reflect the moral judgment of the people of that state as expressed through their elected representatives. But what do we do with a situation, and let's say that if a state made the law through case law without thinking that it had to do something one way or the other because of our decisions about constitutional standards. Put that aside. What do we do with a situation like we have here, where state courts and lower federal courts are trying to figure out what we said and what Hall and Moore mean? And so their decisions reflect their interpretations, perhaps erroneous interpretations, of those two precedents of this court. Do we look at those to see whether there's a national consensus?
No, I don't think so. I think there's a difference between the idea for a national consensus is when a certain moral judgment has the imprimatur of the people. I don't think that happens when a court imposes that standard on an incorrect understanding of federal law. So to the extent that this court is still doing head counting for purposes of Eighth Amendment, I don't think that courts misunderstanding Hall or Moore would factor in favor for whatever new rules being proposed.
Now, I don't know whether you've surveyed the state statutes, so perhaps you're not in a position to answer this question. But if one were to survey the statutes of all the states that have the death penalty and see whether they have adopted one approach or another approach to the situation we're dealing with here, what would we find?
So I can't speak to the legislatures just because I don't know what was motivating them. Alabama was able to catalog, I think, a few examples in their brief of instances where state courts were applying what is essentially the one low score rule. That erroneous understanding of Hall and Moore, which again we all agree is an erroneous understanding of Hall and Moore, I don't think that that counts as a moral endorsement for the one low score rule.
Now, Justice Kavanaugh asked your friend about the advantages and disadvantages of a safe harbor as opposed to the alternative. And maybe you would I'd be interested in what you have to say about that. If there's a safe harbor in the sense that a person sentenced to death who's claiming intellectual disability has to meet some concrete standard before the case can go on, will there not be greater consistency and predictability? And is that not one of the lodestars of the court's death penalty jurisprudence, as opposed to a situation where everything is up for grabs in every case, and both sides can bring in experts to testify about the person's intellectual disability or lack of intellectual disability, and every trier of fact is going to decide that on an individualized basis.
So I 100% agree with that, Justice Alito. If I can just emphasize one point, because I don't think there's any practical daylight between what I'm saying and what Alabama was just talking about. I think just the point I was making before is there might not be a per se legal bar on looking at the other evidence, but the IQ evidence may nonetheless be practically dispositive in a given case. So what I'm understanding essentially what my friend was saying is, well, if we look at the IQ scores, it was the defendant or respondent's burden to essentially show at step one that the error range of those scores together reaches 70 or below. Because even if that range never reaches 70 below in the first place, there's no realistic possibility that any of this secondary evidence on the other side of the scale is going to drag you over. So I think that that's more of a practical matter with the facts of this case, where IQ happens to be dispositive just because there's not going to be anything on the other side of the scale that tips it over.
Thank you.